combating of terrorism in all its facets, including terrorist financing. It criminalizes the raising funds for terrorist acts, holding proceeds of terrorism, membership of terrorist organization, the support given to a terrorist organization and raising fund for the terrorist organization, the support given to a terrorist organization and raising fund for a terrorist organization. UAPA 1967 also provides the effective prevention of certain unlawful activities of individuals and associations and for the matters connected therewith. The scope of the Act was widened in 2004 and the terrorist activities were brought by criminalizing various facets of terrorism. All political parties joined together and unanimously passed Act 35 of 2008 to amend the Unlawful Activities Prevention Act to overcome some of the difficulties in its enforcement and to update the legislation at par with international commitments and make certain provisions that made the Act more effective and stringent. It is also relevant to mention about the Financial Action Task Force. The Financial Action Task Force, an intergovernment organization set up to devise policies to combat money laundering and the terror financing. It admitted India as its 34th member in June 2010 on the basis of commitment made by India at the time of admission to FATF. The various legislative and other legally binding measures were required to be taken on a medium-term basis. That is, by 31st March 2012, including some changes in the UAPA, these are also being accounted for in the amendment bill. Further, an interministerial group which evaluated the existing provisions of UAPA 1967 and recommended other necessary amendments to the said Act in order to deal with the current threat scenario. The Unlawful Activities Prevention Amendment Bill 2011 was introduced in the Loksabha on 29 December 2011. The bill was referred to the Parliamentary Standing Committee on Home Affairs. The committee gave its report on 28 March 2012. Out of the 14 clauses in the bill, the 10 clauses have been recommended for adoption without any change by the Standing Committee. The committee has recommended changes in 4 clauses of the amendment bill. Thereafter, the matter was referred to the state governments. Thus, the bill before this House today has taken into account the recommendations of the Standing Committee as well as the observations of the state governments. I would like to highlight some of the salient features in the proposed amendment Unlawful Activities Prevention Amendment Bill 2011 before the House. The bill proposes to A. Increase the period of declaration of an association as unlawful from 2 years to 5 years as specified under Section 6. B. We amend Section 15 of the aforesaid Act, which defines Terrorist Act, to include therein A. 1. The economic security and damage to the monetary stability of India by way of production or smuggling or circulation of high-quality counterfeit Indian paper currency, coin, or any other material as the existing provisions of the aforesaid Act do not include within their scope an act done with the intent to threaten or threaten likely to economic security of the India and counterfeiting Indian paper currency or coin. 2. Any international or intergovernmental organization against which any person indulges in act described in Clause C of the Section 15, since the existing provision does not explicitly mention such international or intergovernmental organization. 3. The act of demanding any bomb, dynamite, or other explosive substances or inflammable substances or firearms or other lethal weapons or poisonous or noxious or other chemicals or any biological or radiological nuclear material or device with the intention of aiding, abetting, or committing terrorism. C. Enlarge the scope of Section 17 of the aforesaid Act relating to punishment for raising funds for the Terrorist Act and include within its scope raising of funds both from legitimate or illegitimate sources by a terrorist organization or by a terrorist gang or by an individual terrorist. D. Insert new section 22A, 22B, and 22C in the aforesaid Act to include within its scope the offences by companies, societies, or trusts and provide punishment therefore. To conclude, the proposed amendment to the Unlawful Activities Prevention Act 67 thus aim to bring more clarity to the existing legal regime and remove the deficiencies identified in the implementation of the provisions of the said Act by central and state intelligence and investigating agencies. I am sure that these objectives will achieve with the consensus of the House. Thank you.